You do not allow consumers actually to delete permanently their data. And when you said a minute ago to Senator Moody, at all times consumers have complete control of their data, that's just not true, is it? By the terms of your own agreement, that just is not true.
Senator, with all due respect, all of the genetic data is deleted. We are only
With all due respect, what you are telling me is in direct contravention to what your own policy states. Here's my point. It's a pattern. Your consumers actually aren't in control of anything. You are. You control their data. You control their genetic information. Now you're about to sell it. You promise them, we won't ever sell it without your consent, but you're doing it. You promise them, we'll allow you to delete it, but you don't. In fact, you've lied to them. Have you not? I've seen what they are, and I tell you what, it's amazing to me you're not getting your socks sewed off by your customers. I hope they will. I hope they will rush to the courthouse, even as we are here today, to sue you into oblivion for lying to them and taking their most personal, identifiable information and selling it for a profit and lying to them and to the American public. Quite frankly, Mr. Savage, what you're doing here has all kinds of implications, national security implications, all of it, but nothing is worse than taking the personal, identifiable information of American consumers and keeping it and lying to them about it while you make a huge profit off of it. It's unbelievable to me. Mr. Savage, if I could just start with you. So how many customers do you have approximately?
Between 14 and 15 million customers.
Between 14 and 15 million. I think you told Senator Britt just a minute ago that a goodly number of those are minors. Is that correct?
What I said was I don't have the number of customers.
You have the genetic data of a good many minors. Is that correct?
We have genetic data for a particular number of minors, and I will be happy to provide.
People under the age of 18. Is that correct?
That is how I'm defining a minor.
So they give your customers, I just want to make sure I understand your business model. Your customers give you their genetic information for you to run various tests on. Is that right?
Yes, that is correct.
And I mean, that's pretty sensitive stuff, isn't it? Somebody's genetic information. Is there anything more personal than that?
I would agree with you, Senator, that genetic data is sensitive information.
And so now you're just going to sell all of it? 15 million people, bunches of kids, maybe millions. It's just going to be sold in the open market?
As Senator, the good news, as I mentioned, is that the two bidders or buyers for the company, one is Regeneron, which is
That's the big pharma company? It doesn't make me feel any better.
It's a large pharmaceutical company.
All right, so you're going to take 15 million Americans' genetic information and you're going to sell it to somebody, and your message to us is today, trust us, it'll be fine. Maybe it's a big pharma company. Maybe we'll get lucky. Maybe they'll treat it right. I thought your privacy code, your privacy commitment said that consumers had a right not to have their information shared with anybody else without their consent. I mean, I've got your privacy statement right here. It says that without their consent, you can't share their information. You're about to sell it.
Senator, that consent is, essentially for,
not real?
Not share for research purposes, and we are not selling it for research purposes.
So when you tell the consumer, give us your personal information and we'll take money from you, and we won't give it to anybody without your consent, it's not real. It just means, maybe kind of depends on the day.
Senator, I will say that our customers' data is their own. They have the right at all times to access that information. They can edit it.
Well, sure they can, but you're about to sell it to who knows who. They can't control it. You said to Senator Moody that consumers have complete control of their data. Complete. How can they have complete control if you're about to sell it without their consent?
Senator, they can delete that data anytime up until the sale. And
what happens when a company promises consumers control over their most sensitive data, but its own policies contradict that claim? In this hearing, we see a direct clash between corporate assurances and reality, raising serious questions about accountability, privacy, and the legal limits of consumer protection.
Okay. They can delete the data. Have you fixed the ability of customers to go on your website and delete it? Because right after you announced your sale, your deletion page went down. I hold in my hand here an article from the Wall Street Journal. 23andMe site goes down as customers struggle to delete their data. Can they even get onto your site to delete their data?
They can, Senator. And
you fixed this?
That was an issue that, yes, we fixed immediately after.
It's up and running now? Customers can go on?
Customers can go on and they can delete their data.
What happens when they go onto your site to delete their data?
When a customer logs into their account at 23andMe, They go to their settings page, and there's a section there where just click delete my data. It confirms that they want to delete their data, and it's deleted automatically.
Is that true? Let's take a look. Let's take a look.
Okay.
When they go onto your page, they get an opportunity. It says permanently delete the data. So they click the button that says permanently delete the data, and then they get a notification that says your account is no longer accessible. How do they know if they can't access their account anymore? How do they know their data's been deleted?
Because we send them a notification that their information has been deleted.
You send it once, and how long does that take?
Our policies state that, we will delete their data within 30 days, and in most cases, it is automatic and happens much quickly.
And when you delete it, it's deleted. It's gone forever.
All the genetic data is deleted forever, and yes.
Really? Because that's not what your privacy statement says in the fine print. Let's read it. What your statement says is, we retain personal information for as long as necessary to provide the services and fill the transactions you've requested, to comply with our legal obligations, resolve disputes, enforce agreements, et cetera, And then it goes on, 23andMe and or our contracted genotyping laboratory will retain your genetic information even if you choose to delete your account.
Senator, 23andMe, it does not retain any genetic information regarding the consumer once they delete their account. We do.
It says right here that you will retain genetic information, including date of birth and sex, even if you choose to delete your account. This is your privacy policy. I'm just quoting from it.
Senator, to the best of my knowledge, we do not maintain any genetic information.
It says even if you choose to delete your account, we will retain your genetic information, date of birth and sex, even if you choose to delete your account.
There is some information that we do retain, but not related to the genetic information.
Right.
But that, such as name, email address,
and
other.
So even if you delete the account, you retain their name, you retain their email address, you retain their date of birth, you retain their sex, and you retain their genetic information, even if they choose to delete your account. So in other words, don't talk to your suit behind you. Talk to me. He's not testifying. You are. You do not allow consumers actually to delete permanently their data. And when you said a minute ago to Senator Moody, at all times consumers have complete control of their data, that's just not true, is it? By the terms of your own agreement, that just is not true.
Senator, with all due respect, all of the genetic data is deleted. We are only
With all due respect, what you are telling me is in direct contravention to what your own policy states, even if you choose to delete your account. In fact, what you do is you allow your consumers to delete their account settings, but their data isn't deleted. You still have it. The laboratory still has it. You have their name. You have their date of birth. You have their sex. And now you're going to sell it. Here's my point. It's a pattern. Your consumers actually aren't in control of anything. You are. You control their data. You control their genetic information. Now you're about to sell it. You promise them, we won't ever sell it without your consent, but you're doing it. You promise them we'll allow you to delete it, but you don't. In fact, you've lied to them. Have you not?
Senator, we have not. I assure you that we are deleting all of our customers who have requested.
No, you're not. You're not, because your policies say they're not. And you're not deleting it because if you were, your company wouldn't be worth $300 million. No, don't read from what your guy behind you is shoveling talking points to you now. I don't want your talking points. I've read your policies. I've seen what they are. And I tell you what, it's amazing to me you're not getting your socks sewed off by your customers. I hope they will. I hope they will rush to the courthouse, even as we are here today, to sue you into oblivion for lying to them and taking their most personal, identifiable information and selling it for a profit and lying to them and to the American public. Quite frankly, Mr. Selsavage, what you're doing here has all kinds of implications, national security implications, all of it, but nothing is worse than taking the personal, identifiable information of American consumers and keeping it and lying to them about it while you make a huge profit off of it. It's unbelievable to me. It's absolutely unbelievable.
Professor Gottberg, California has already passed legislation that went into effect in 2022, requiring direct-to-consumer genetic testing companies like 23andMe to obtain Californians' express consent for the collection, use, or disclosure of their genetic data. Under this law, Californians are also able to delete their accounts and genetic data and to destroy the biological samples they provided to these companies. In the context of 23andMe's bankruptcy, can Californians still exercise these deletion rights? Or does the bankruptcy process somehow interfere with, override, or otherwise affect our state's privacy protections?
Thank you. Bankruptcy proceedings do not override any applicable law. So state law and federal law are recognized in bankruptcy proceedings. Whatever rights your consumers have outside bankruptcy, they'll have inside bankruptcy in terms of their legal rights.
And if the database, 23andMe's database, is sold as a bankruptcy asset, what obligations would the acquiring company have under federal or California law to maintain those same security standards?
So the same laws that would apply now to 23andMe would presumably apply to any buyer.
Even if this is not a California company operating in some other state, they would still be bound post-bankruptcy to California's privacy standards?
To the extent that California privacy standards apply, yes, they would.
And is a commitment made by an acquiring company somehow enforceable? Apart from California's law, vis-a-vis residents of other states, is a promise made by an acquiring company somehow legally enforceable, or is it only as good as the person's intention to comply with that commitment?
So contractual promises are enforceable up to the point that they can be enforced. That's not a great answer, but again, our statement is a contract is a promise to perform or to pay damages. It's possible for parties to breach that agreement, in which case the party that on the other side of it would be entitled to damages for the harm that they've experienced. But without,
I guess, let's say I'm acquiring 23andMe's data set. I commit to maintaining the deletion provisions, et cetera, complying with California law, even if it's not required somehow. I acquire the data set. I don't comply.
right.
Has my offer to comply or my commitment pre-bankruptcy, has that somehow turned into a binding contract with the owners of the genetic data, the people who have the genetic data?
So it would depend on who you were in privity with, I guess, in terms of the contract, to use, a fancy legal term. A contract is between two parties, and so you have to have an agreement between those two parties. And I guess the question in those situations, if you were promising to abide by the commitment, who would be on the other side of that promise? Who would be able to enforce it?
Right. Well, it would sound like the consumer would not be on the other side of that promise. It would be more one of the parties to the bankruptcy, which would then we would be then reliant on them to enforce that promise. Does that analysis make sense?
That makes sense to me.
And what controls are in place, Mr. Salsavage? Maybe I can ask you this question. What controls are in place to prevent any unauthorized access or misuse of information during the bankruptcy proceedings?
23andMe is, basically places data security and data privacy is top of mind. We basically have continued to maintain a strong system of security, making sure all of our data is encrypted. The genetic data is stored separately from any consumer identifying information, identifying who that genetic data belongs to. We have enhanced our security processes, especially around bankruptcy, understanding that there is additional threats. And, basically on the consumer side, we have since enacted two-factor authentication so basically there is a second level of either an SMS text message or an email verification when somebody's trying to access their account, and then placed additional restrictions if
I can just interrupt with one last question because my time is going to expire. How do we know that an acquiring company or entity or person would maintain the same security standards that you have over privacy, and even those standards were subject to hack?
Senator, the good news here is there's two potential buyers at this point for 23andMe. The first is Regeneron, American $55 billion market cap pharmaceutical company who actually has data security over genomic data today, and TTAM Research Institute, which would be maintaining the same security standards as 23andMe.
In this hearing, the central issue revolves around consumer control over personal genetic information. The company in question repeatedly asserts that customers can access, edit, or delete their data at will. Yet, when these claims are tested against their formal privacy policy, a clear contradiction emerges. According to the company's own terms, even after a consumer requests deletion, certain elements, such as genetic information, date of birth, and sex, are retained by the laboratory and the company. This structural gap between promise and practice forms the crux of the oversight challenge. The senator's line of questioning highlights the practical implications of this gap. When the company says all data is deleted, they are technically referring only to account-level access, not the full erasure of sensitive information. The transcript shows repeated attempts to reconcile these assurances with the written privacy policy, exposing a structural weakness. Corporate statements to the public are not always enforceable. The hearing explicitly tests these promises, not through hypotheticals, but by referring directly to the company's published commitments. The scale of the issue is significant. Between 14 and 15 million consumers are affected, including minors. This is not a minor discrepancy. It is a systemic risk to privacy. The senators point out that the company plans to sell this data to third parties, potentially without meaningful consent. From a legal perspective, the hearing surfaces a critical tension: contractual obligations versus enforceability. Even if an acquiring company promises to comply with deletion standards, consumers themselves may lack the legal standing to enforce those commitments directly. Instead, enforcement may rely on bankruptcy proceedings or contractual oversight between corporate parties, not individual rights. Institutionally, this demonstrates how structural gaps can undermine regulatory intent. Federal and state laws, like California's genetic privacy statute, offer protections, but their enforcement depends on clarity of obligation and corporate compliance. The hearing raises the question of whether corporate bankruptcy could dilute these protections, even though legal experts confirm that bankruptcy does not override applicable state privacy laws. Still, the practical enforcement of those laws depends on either litigation or regulatory intervention. Security during the transition of ownership also becomes a critical concern. The company details encryption, separation of identifying information from genetic data, and two-factor authentication to mitigate risks. However, as the senators underscore, these systems are only as reliable as their implementation and maintenance, and they cannot eliminate the structural question of who controls the data after a sale. The distinction between technical security and legal control is fundamental. Even perfectly encrypted data may still be subject to transfer under corporate transactions. Repeatedly, the senators return to the theme of accountability. Promises of deletion, assurances of consumer control, and commitments to maintain standards post-sale are only meaningful if they can be enforced. The hearing demonstrates that enforcement mechanisms, state law, contractual remedies, and potential litigation are distinct from corporate messaging. This distinction is where institutional oversight is most relevant. Democracy depends on enforceable standards, not merely on corporate goodwill. In broader context, this hearing exemplifies a recurring pattern in regulatory oversight. Corporate statements often overstate consumer rights, while written policies retain privileges for the company. Without careful scrutiny, such practices can erode trust and create long-term systemic risks, particularly when highly sensitive information is involved. Genetic data, by its nature, cannot be anonymized in a meaningful way. The stakes for privacy, commercial exploitation, and national security are uniquely high. The takeaway is structural rather than emotional. Oversight does not rely on outrage. It relies on verifying that institutional promises, laws, regulations, and contracts are aligned with actual practice. For policymakers, analysts, and the public, hearings like this reveal the mechanisms by which private actors may circumvent stated obligations, intentionally or otherwise, and why enforceable safeguards are essential. Ultimately, the hearing is a case study in the gap between promise and reality. It underscores the need for clarity in privacy policies, enforceable rights for consumers, and rigorous oversight during corporate transactions. For viewers, the lesson is clear. Understanding the structural dynamics of accountability is key to protecting individual rights, particularly in domains as sensitive as genetic information. Awareness and legal literacy are the first defenses against institutional erosion of trust.